Professor Murray, what do you make of the test, what we heard from the defense attorney anyway, in Minneapolis today, saying that these two officers were only on the force for 4 days and that they were simply obeying what their training officer was telling them to do?
Well, I guess we're getting a glimpse of what the defense will be for these three officers as they mount their defense to these charges of aiding and abetting. And the idea here is that these are junior officers following the chain of command. Chauvin was a much more experienced officer, and he was setting the pace and the tone of this encounter.
And also, on this case in Georgia, what was the reaction when you heard that testimony today about one of the defendants quoting the other defendant after the shooting?
Well, the introduction of the racial slur obviously heightens and escalates this. Many people already believe that this was a racially motivated incident, and that slur would seem to confirm that. As a matter of state law in Georgia, there is no hate crime statute under Georgia law, but of course the federal government has a federal hate crime statute, and the federal government is already investigating this, and the addition of that slur evidence would certainly help make out a better case for prosecution under a federal hate crimes law.
And just to go back to Minneapolis again, the new charges and the elevated charge against Derek Chauvin, what is your reading of how you expect those charges to proceed in court compared to what the original complaint was?
Well, so Keith Ellison is very clear that the escalated charges were intended to weigh the gravity of this particular situation, and third-degree murder, which was the original charge, was simply not serious enough to sort of reflect what had happened here. So the second-degree murder charge, it's a felony murder charge, which is simply the commission of a murder in the conduct of some other felony, here an assault. The escalation to a second-degree felony murder charge would help bring in the other defendants, bring them in on aiding and abetting, because they could also be part of this as well. And it's much easier, I think, with a specific intent charge like felony murder to bring in the other accomplices as like accomplice vicariously as accomplice liability on a charge like that, as opposed to a murder charge that simply requires recklessness or negligence as the underlying mental state. So I think it was both reflecting the political climate that demanded more from the state in prosecuting these officers, but also a tactical maneuver designed to also include these three other officers.
And in the Minneapolis prosecution, we did get that peak today and that new knowledge that two of these officers were in their fourth day on that police department. Do you suspect there's going to be a possibility of separating these cases into individual trials, or in some way separating them out of something other than four defendants sitting there for one trial?
Well, for matters of economy, they will likely be tried together. But of course, each defendant is represented by his own counsel, and each counsel will present his own defense of his client. And so there may be opportunities here, certainly now, given the nature of the charges, for each defendant to perhaps cooperate with the authorities, cooperate with the prosecution, provide evidence against the other defendants and Mr. Chauvin himself. So these are going to be tried in concert, but they are four individual defenses.